Well, good afternoon and welcome to our 2020 primary election virtual candidate forums. If you're on social media, please hit the share button and make sure all your friends have the opportunity to see the discussion today as well. My name is Jim Rossica. I'm the news director of the Tallahassee Democrat, and I'll be today's moderator. I'd like to thank our partners, the League of Women Voters of Tallahassee. And now I'm going to introduce Christine Coble, who will be asking the questions for the League. Christine, say hello.
Hello.
Thank you and welcome. Thank you for being here. Periodically, you'll see both our election websites on your screen, where you can find more information to help you figure out how to vote with confidence. We're here today with the candidates for public defender for the state's Second Judicial Circuit. The incumbent is Andy Thomas. Good afternoon, Mr. Thomas.
Good afternoon. Thank you for having me.
Thank you for being here. And his challenger is Jessica Yeary. And Ms. Yeary, good afternoon to you.
Good afternoon, Jim. Thank you for this opportunity.
Thank you as well for being here. And again, I should ask the technical question, which is, everybody can hear me okay?
Yes, sir.
Okay. And so here's how it will work. We will take turns asking questions. We'll rotate which person gets to answer first. We are going to ask you to keep your answers to 90 seconds. I will try to keep time, and I will give you a signal when your time is up that should sound like this. If you are in the middle of a sentence, when you hear the buzzer, try just to finish that sentence so we can move on. We also are, I'm sorry, if you're watching on Facebook or YouTube and you have a question for the candidates, go ahead and type them in the comments section. We'll get to as many of them as we can. Obviously, time is limited, so you can improve your chances of your question being asked if you keep it brief and polite, making it a question applicable to both candidates. Are there any questions from either of the candidates for office?
No.
Okay, hearing none, we will just go ahead and start with the first question, which I will ask. Ms. Yeary, you will go first to answer. And the first question is, being a public defender is an often thankless job with a large number of cases and never enough resources. What inspired you to make this your life's work? Ms. Yeary, go ahead.
My first day of my internship at the public defender's office in St. Petersburg, we went into the juvenile detention center, and I walked into that room and there was a 12-year-old boy sitting at a school desk and he was shackled there. And the adults in the room all walked around him as if this was normal and was not a big deal at all. And I watched in awe as my supervising attorney at the public defender's office kneeled down next to him, rubbed his back, whispered in his ear, and told him it was going to be okay. And we were successful in getting him released from custody that day. But that was the exact moment where I knew I would just spend my entire career defending people accused of crime. And that's what I've done over the past decade. I started at the public defender's office here in Leon County and was promoted to positions of leadership throughout my career there. People don't become public defenders because they intend on getting rich or because there's, a lucrative option there. We become public defenders because we care about the people we represent and we want to make a difference for them and their families. And it's incredible work. Sure, we have high caseloads, but I am most proud, with the exception of my husband and our 2 children, I am most proud of being a public defender and seeing my clients succeed throughout the entire system.
Okay, thank you very much. We'll reset the timer, and Mr. Thomas, go ahead and take that same question.
Thank you. I've been in public defense now for over 35 years. I had a similar experience when it came to juveniles. It started, though, in 1981 when I began practicing law in Tampa, Florida at the Public Defender's Office. And I had a couple of children that just broke my heart. They had parents that were either disengaged or substance abuse addicted. They were afraid to talk in front of their parents. And I learned very, very early on how important it was to develop a rapport and a trust with your clients and how you could help them, how you could change their lives. And so that was the first step. The second step, though, was after I started doing capital law and actually represented men and women who were being threatened with the death penalty, and either at a trial level or a post-conviction level. And that's when it solidified in me that I would do this for the rest of my life. I had tried a couple of other things, nothing set like this. So I came in 2000, joined Nancy Daniels, and I was with her until 2016 when she retired. So I've been in this office for 20 years. I've been in a position of supervision or chief assistant or the public defender for 16 years. So my dedication to poor people and to helping people and setting them up for success and viewing them as whole people and trying to help them redirect their lives should be obvious at this point. That's what I've dedicated my life to.
Very good. Right on time, sir. Thank you very much for the answer. Ms. Coble, we're going to pass it over to you for the second question, and Mr. Thomas, you'll start. Ms. Coble, go ahead.
What administrative changes do you propose to make in the first year if you are elected?
I don't plan to make any administrative changes because I'm quite happy with my first term administration. I have a budget director and an administrative executive director who watches the money very closely. We're going to be facing a huge budget crisis in the coming fiscal year. We know we're going to have a 6% cut, which is $600,000 in a $10 million budget. This office is 65 attorneys, 130 employees total over 6 counties doing appeals in 32 counties. So I have an established team of personnel director, of budget people, a chief assistant, unless she's elected judge. And if she is, then I will have to make a change there administratively. But other than that, I do not anticipate administrative changes.
Ms. Yeary, you can go ahead.
Thank you. One of the first things that I will implement is a formalized training program for the lawyers in our office. There are other public defenders' offices throughout the state that have this formalized training program. And why it's so important is because it gives our lawyers the tools and skills that they need to be the lawyers in the courtroom that our clients deserve. And I want to be clear on that. There is no formalized training in the office right now. If you're hired in the office, you're given a caseload and you're sent into the courtroom without any formalized training. And that's a disservice to the people that we represent. So first and foremost, I will implement the formalized training program that I tried to do in the office when I was there. On top of that, we have seen continued disparity and inequality in the sentencing of our clients. And one of the programs that has been critical in highlighting that is the Equity in Sentencing Analysis Program. That is a technological program that shows sentencing disparity and gives us the tools to get in there and argue for our clients. And so it's one of the first things that I will implement. So we have that data to back up our motions, because we've been seeing this in the courtroom every single day. And we know that our clients are treated differently and there is sentencing disparity. So by implementing that program, we will have that data to use, and we will have the formalized training that gives our lawyers the skills they need.
Thank you, Ms. Yeary. Mr. Thomas, I guess I need to go to you for a response to her statement that you do not provide formalized training to your assistant public defenders. Go ahead and take that for 30 seconds.
Okay, that's simply untrue. We send our new lawyers to Defender College, to several Florida public defender sponsored These are courses that are well established, that have been proven to be effective in getting young lawyers on their feet. The other part of that, when you're in a position of leadership, as has been mentioned, one of your jobs is to mentor and to help train. The greatest on-the-job training for an assistant public defender is to watch a seasoned lawyer do their job.
Thank you. You just beat it. I'm going to go ahead and take the next question, and this will go to Ms. Yeary first. And it kind of echoes what you just said. Do you believe there are racial disparities in how defendants are treated, specifically in Leon County? I'm going to guess you're going to say yes to that. And talk a little bit more about what can be done to address that.
So there are sentencing disparities, and I know that from being a lawyer in the courtroom now. I'm still in private practice. I had hearings this morning where I argued for clients' releases. So we know that there's sentencing disparity in the work that we do. On top of the data that we have and implementing that program, so we have that information to show to our judges, we also have to be skilled lawyers. One of the biggest issues is that, unfortunately, we've lost the trust of our community, and they don't believe that lawyers in the public defender's office are just as committed, are just as skilled, and are just as legally ready to get in there and fight. One of my proudest accomplishments is that I'm board certified in criminal trial law through the Florida Bar, which would be our standard for representation for all lawyers in the office. The Orlando Public Defender's Office ensures and encourages and supports their lawyers to earn that credential so that they can make sure their clients are receiving the best representation. The way we fight back about the sentencing disparity and the way we fight back on these issues is to be skilled lawyers and to highlight through our motions, through our litigation, and through our presence in the courtroom and the community when we see these injustices, and speaking out against them and making sure that our lawyers have the tools that they need to fight for our clients.
Thank you very much. Mr. Thomas, go ahead and take that same question about racial disparities and what can be done.
Yes, sir. As I say, I've been doing this since 1981, and nothing has changed during that period of time. There's been racial disparities since the beginning of my practicing law. What that puts on the individual lawyer is an obligation to fully understand the client's background, the whole person, the client's family of origin, any trauma they've gone through. Why is it that my African-American client is living in a disadvantaged neighborhood, has income challenges, has food challenges, has educational challenges, and how do we redirect that, and how do we try and change that by disposition? So that's how you change disparity in sentencing, is you do a better job lawyering, number one. You work as a team, you work with your social workers, you work with your experts, and you present a better case. The other thing you do is you try and get the police to quit arresting disproportionately large numbers of African-American people, because we know that TPD, for example, arrests almost 70% African-American people, and they only make up 35%, 30% of the population of this county. So our policing has to change and our lawyering has to improve, of course.
Mr. Thomas, thank you very much. The next question will go to Christine Coble, and Mr. Thomas, you'll answer first. Christine Coble, go ahead.
Thank you. What do you think of the current working relationship between the Second Judicial Circuit offices of the state attorney and public defender? Could that relationship be improved upon? And if so, how?
Thank you. It's the only way I can describe it is Mr. Campbell and I can talk. It's an improvement over the last administration because there is more dialogue. I believe we're better on administrative issues. I believe we're better on talking about, for example, trying to get people out of jail during COVID-19, deciding when to reopen, not reopen this courthouse, how to keep our people safe, that type of thing. We get along very well on those issues. On criminal justice, on how his assistants prosecute cases, on the timeliness of discovery, on the reasonableness of plea offers, on the absolute necessity of trying cases that should not be tried, but simply have to be tried because there will be no reasonable disposition offered, I would say that there is vast room for improvement. And again, what happens is the entire burden goes to the defense bar, because you almost have to go in on your knees with a plan of success, having done all of this work in order to try and get a reasonable disposition. And then frequently the prosecutor doesn't listen and just says no. Okay, that should change. And how you change it, I agree. I think that we have to litigate, have to try cases, and we do. We have the #1 trial rate in the state, in the circuit. So if trying cases was going to reform them, perhaps it would have already taken. I don't know the answer to that. We just have to keep fighting.
Thank you. I want to speak directly to the trial statistic first, and I'm going to read this directly because this information is important. My opponent has been using these trial statistics as a measurement of the work that has been done, and the group that puts out that information specifically warns against doing that. This data comes from the Florida's Trial Court Statistical Reference Guide, which was issued in March of 2020 by the Florida Office of the State Courts Administrator. And in that introduction, it specifically says that this data is not intended to measure the work of state attorneys or public defenders. The reason that's important in relationship with the state attorneys is because the way that we make change when we know that change hasn't happened over the past couple decades, the way we make change is by being strong litigators. And that comes from being lawyers in the courtroom that are skilled and ready to challenge the evidence. Because when a prosecutor does not give you the plea offer that you are asking for, or when a prosecutor withholds evidence or doesn't turn over discovery in the proper way, which is oftentimes what we see in the courtroom, then you have to be lawyers that are in there and ready to fight. These trial statistics come from cases that I have tried and my colleagues in the trenches have tried, because the biggest difference is that the current public defender doesn't carry a caseload and it's not in a courtroom. So the way we do make that change with the prosecutors is, of course, by working together, being professional and ethical on the logistical issues that we can. And I do that as the president of the Tallahassee chapter of the Florida Association of Criminal Defense Lawyers, but also skilled litigants in a courtroom and attorneys that are ready to fight.
Thank you, Ms. Yeary. Mr. Thomas, I feel compelled to give you 30 seconds as a follow-up to that. Can you talk to us a little bit why you are not, as Ms. Yeary is stating, not trying cases as your predecessor did in the courtroom?
My predecessor did not try cases in the courtroom. Nancy Daniels covered drug court, is what she did, which is a therapeutic court that meets every 2 weeks. The difference is that Ms. Daniels had been in office for 26 years, and she didn't need to learn all the administrative things that she had acquired over time. I have been trying cases since 1981. I'll put my trial statistics up against my opponents any day of the week. I don't need any more trial experience. I don't need to do any more capital cases and walk people out of the courtroom with a not guilty on a self-defense case. I don't need to do any more trials. What I needed to do was learn how to go get money across the street, which I have done. I have to learn all the administrative things that come with this job of managing 6 counties and getting improvements to the office, getting improvements in technology, and keeping the boat afloat every day.
All right, Mr. Thomas, thank you very much. I gave you a little bit of extra time to expand upon your answer. And you just stated something that reminds me I should have made clear at the very start of this was the counties that are included in the Second Judicial Circuit, and they are in no particular order: Leon, Gadsden, Wakulla, Jefferson, Franklin, and Liberty. So the Second Judicial Circuit Public Defender's Office represents indigent criminal defendants in all of those counties. Should have said that at the beginning, but you've jogged my memory, so we've got that out now. It's going to come back to me for the next question. Ms. Yeary, you're going to answer first. That question is, what is being done and what should be done to prevent further coronavirus outbreaks in the Leon County Detention Center? Ms. Yeary, go ahead.
As lawyers in the public defender's office and criminal defense lawyers, the first thing we have to do is advocate for release of our clients. As a practicing attorney now, that's what I have done. And what I would do differently is I would require that every single client of ours had a motion for release filed in their case, every single one. because there should have been a judicial determination on every single case of people that are currently in the detention center. The biggest thing to remember here is that people that are sitting in a county jail have not had their day in court yet. They are accused of a crime. And so at that point, we need to be advocating for their release when this pandemic happened. And that would be the first thing that I would have required. I've been working with the task force on reopening the courts, and we're looking at how things are going to handle down the next couple months as we work through this pandemic. Also, one thing that we've instituted that I have worked on is the community bailout fund, and making sure that clients that don't have resources or the ability to pay their financial bond have an opportunity through this program to get out. I'm proud to say I have a client getting out this afternoon from the work that that program has done. And so we have to continue to make partnerships during COVID and during the entire time that we're representing clients to make an impact there. But we can't just say, you know, there's so many clients, there's so many cases. We actually have to be the ones in there that are fighting on every single case and filing the motions. There's the ways that we can do that to streamline them through our technology in the office, and it would have been the first thing that I required.
Ms. Yeary, before I turn to Mr. Thomas with the same question, I do need to, and if I misheard you, I apologize, but it not only are there people awaiting criminal trial in our county jails, but obviously there are also people who are doing misdemeanor sentences, correct?
Some of them, yes. Some of them have been sentenced on the smaller offense levels, but the majority of people are awaiting their day. They're sitting there with a bond.
Okay, I just wanted to make that clear. Mr. Thomas, I'll turn to you for the same question about coronavirus in our local jail.
Okay, thank you. Actually, the jail population is a little more diverse than has been described so far. There are a number of people there that are awaiting transport to the Department of Corrections. They've already been sentenced to prison. The Department of Corrections is only accepting a limited number of inmates per month at this point. There's also a number of people in the jail, and this is a tragedy, that are awaiting transport to Florida State Hospital because they're incompetent to proceed on their cases. But Florida State Hospital has put a moratorium on accepting new patients as well. There are also people serving misdemeanor sentences. There are people being held from other counties. There are people that have holds for violations of probation from other jurisdictions that we have tried to get released, or we've tried to negotiate the case, and they said, no, we want them. And so they have to sit at this point, unless a judge grants release, they have to wait until this thing passes and get transferred to another jurisdiction. We have filed a number of motions. We are not going to file blanket motions in every case because it's a waste of judicial time, it's a waste of attorney time, and it just is a feel-good option. It is not going to result in any more people released. We filed a motion last week on someone that had a $1,000 bond for a nonviolent offense, and the circuit judge denied it because of prior failure to appears. That is, in my view, ridiculous, but that's what happened.
And thank you very much. The next question will be from Christine Coble, and Mr. Thomas, you will answer first. Christine Coble.
Thank you. What would you like to see with respect to bail reform?
Thank you. We've made a lot of headway in that area. I will say we filed a writ of habeas corpus in an individual case that ended up turning into a federal lawsuit that we cooperated with the ACLU, ended up suing the sheriff, as it turned out, in federal court. The sheriff was actually a sympathetic defendant in that case. The case was dismissed, but as a result of that, and also efforts, I was on the sheriff's bail reform subcommittee. He had a little ad hoc committee put together, asked me to serve on that. And as a result of that, we got a bond schedule modified. We got a first appearance process modified. First appearances used to start at 8 o'clock in the morning with no opportunity to talk to the clients or to even review the paperwork thoroughly. The judges would come in without barely looking at the cases and just set bonds by a schedule, which were very unfair to our clients that don't have the income to post money bail. So we got the bond schedule modified. It's only used overnight bonding. It's not used for first appearances. First appearances are now at 11 o'clock in the morning. the sheriff allows us to go in and talk to all of our prospective clients in advance so that we can give the judges particular information about why they should be released. This has resulted in a much larger number of people being released on pretrial release without having to pay money bail. They also waive or let their fees accrue so they're not going to be violated on pretrial release because they do not have money. So we've, to a great extent, eliminated the money issue.
As I mentioned earlier, I've been working with the community bailout committee to create money and funds that are available for clients that cannot afford that bond to be released. One of the things that we will do with bail reform within the office is make sure that we have automatic motions ready to go if people are sitting in custody past certain amounts. In other public defenders' offices, they have that. So if there's a client that's been sitting in for 2 weeks without a motion without the ability to bond out, then they go ahead and get an automatic reduction. Because no matter what the case is or what our chances at winning, it is absolutely not a waste of time to not file a motion for a client. Because remember that is a person that has a family and that has someone in the community depending on them. So every single motion that we can file, we should be filing. Specifically to bail reform, we have to continue to litigate those issues. While people out on supervised pretrial release may seem like a good option, what we've seen prior to COVID is the increasing jail population because people were coming back on allegations of violation of that pretrial release. So we need to continue to litigate reductions in bond amount. We need to support our clients through bail reform and through monetary means if they can't afford it. But most importantly, we absolutely have to be filing these motions on every single case.
Thank you very much. I am now going to take the next question, and Ms. Yeary, you will answer first. We're actually going to take an audience question. Question from the audience is, if elected, what will you do, if elected or re-elected, what will you do to promote your office's existence and accessibility to the community at large?
So that's one of the biggest issues that we've seen as I've been out, and I'm proud to have the support of so many lawyers that are public defenders with me, is that's the biggest question. Who is the public defender? We have to be an ally in the neighborhood, and I will absolutely be present not only in the office, but in our neighborhoods and in our community and working with all of the incredible boots on the ground leaders that are making differences in their own neighborhoods. We have to be present so we know what the issues are and we work together to fix them. Because the first time that you meet your public defender shouldn't be when you walk into the courtroom. So we absolutely have to earn back that trust, but that comes from being present and doing the work. Setting the example in the courtroom, knowing that clients will see us in the courtroom because you see it all the time. Jack Campbell tries cases, and absolutely I will be in there trying cases. It is not true that Nancy Daniels only did drug court. Nancy Daniels did all of the juvenile resentencings, and I know that because I did them with her. So it is absolutely unacceptable to be in this position. It is a privilege to serve as an elected official, and the way that we will promote our accessibility is by showing that we care, by being present and doing the work.
Thank you very much. Mr. Thomas, 90 seconds. Go ahead.
The first thing you do for accessibility is you appoint very wonderful chief assistants in all of your outlying counties. And I think if you would check in the 5 counties outside of Leon, you will find a population, a clientele that absolutely loves the person that is there serving them. So the first thing is personnel selection. The second thing is having an internal performance type of monitoring system where we know whether or not our attorneys are returning phone calls. We know whether or not there are being client complaints that are being filed, and they have not been filed. In fact, we're not getting very many client complaints whatsoever. The big thing I want to do for being out in the community more is to have a mobile services van that we've already purchased. We need to modify it to make it a law office. I've already talked to various pastors in the community that will agree to allow us to go out on a Saturday or whenever and do a volunteer day and publicize it so that people that cannot get to our office can get to the van in their local community and get some advice from the public defender's office. And this will assist them and understanding that we are available, we do care, and we're coming to you. I believe that's the future of public defense. That's the future of mental health and social services, which we also stress very strongly.
Mr. Thomas, thank you. I feel compelled to ask one quick follow-up question. Are you at liberty to name any of the pastors that you've said you've spoken to?
Well, R.B. Holmes has agreed. Stanley Walker has agreed. I believe Reverend Wright over in Lake Bradford Road would do it. But there are a number of them that I've spoken with so far, and those are the three that I can recall right off the top of my head.
All right, thank you. Ms. Yeary, do you have a question based on my question? All right, thank you very much. The question asking turns now back to the Democrat. Mr. Thomas, you will answer first, followed by Ms. Yeary. The question is, Florida's direct file law allows prosecutors to directly file charges against juveniles in some cases and actually mandates it in others. The question is, do you think this is a bad thing and why? Mr. Thomas, go ahead.
Of course, it's a bad thing. In fact, I believe mandatory direct file has been now modified, and that was part of a joint effort between our association and the Prosecuting Attorneys Association. They were trying to fend off greater direct file reform, and we were trying to get it modified somewhat. But direct file is a bad idea. I think if you look at other states that still use the rehabilitation model for children, and even in serious cases, they may have an extended period of supervision beyond 18 or 21, but they will not treat them as adults, taint them for life, make them convicted felons, and throw them in cold, hard cells with adults who have been hardened by the prison experience previously. It's the Southern Poverty Law Center, the ACLU, the Florida Public Defender Association. Almost every session, we propose bills to either abolish or severely limit direct file. We would very much like to at least have a judicial waiver hearing where a judge gets to make a decision based on the facts and circumstances whether or not this is an appropriate case for direct file. Once there is a direct file, we still have an opportunity to get juvenile sanctions imposed. So that means that we have to use our social workers, our mental health, our investigators to put together a full mitigation package and a full understanding of who the child is, so that even if they are in adult court, we may be able to still get them juvenile sanctions.
Thank you, Mr. Thomas. Ms. Yeary, same question to you.
The direct file process is one of the most horrific processes that exists in our criminal courtroom. And those children are the specific cases that I will represent when elected. Those children are charged in an adult courtroom where they have no basis to be. And let me be clear, that decision comes from the discretion of the state attorneys. So the prosecutors carry all of the power in those decisions in deciding who and what charges we will put children into the adult process. One of the last cases that I handled at the public defender's office was a 14-year-old child who was direct filed. And I was successful in getting a youthful offender sentence for him, but we advocated for juvenile sanctions. And I am proud to still be in touch with him and to have a hearing on his case that I took a couple weeks ago to try and get his sentence reduced. The way that we fight back against the direct file process is by being present in the community. Our neighborhoods and our community members have been advocating for restorative justice practices for the past 3 years. They have been out there saying, this is what we want. And I'm proud to have the support of Dr. Bigby at Community Connections, of Kelly McGrath, who is running incredible restorative justice programs. So the way we make change in our community there is by educating people on this process. But the way we continue to make change in the courtroom is how I have been doing it and how I'll continue doing it, which is litigating these juvenile cases and making sure that our clients are getting the downward departure and the sentence reduction that they deserve, because children have no place in adult court.
Thank you very much. The next question goes to Christine Coble of the League, and Ms. Yeary, you will answer first. Christine Coble, go ahead.
What about your leadership style makes you more qualified than your opponent? And a follow-up to that is, each of you have supporters within the office. If elected or re-elected, how do you propose healing those divisions?
My leadership style is different than my opposition because I lead by example, because I do the work. And I wholeheartedly believe that you can't ask your lawyers to get in there and do the work that they're doing with the caseloads that they have without doing it yourself. So I will continue to lead by example by being in a courtroom, carrying a caseload, and being present at the office. The elected public defender should be the first one in the office and the last one to leave. Additionally, what I'm most proud of is having the support of so many lawyers in the office now and those that have left because of the current administration. Our volunteers are committed members of this campaign, are lawyers that are wholeheartedly committed to public defender work and have been in the trenches with me. And they know that my leadership style is one that resonates and makes a difference. I was a division chief for 4 years. I trained certified legal interns that came over from the law school. I coached mock trial team over at the law school still. And I'm proud to have the support of the lawyers that were in my division that still call me chief and ask me their questions about cases that they're handling. As far as fixing the office when I'm back there, we're going to have important conversations and we're going to have to work together this transition. But the number one focus is going to be supporting our lawyers, respecting them and treating them with dignity so that we are all doing our very best work as criminal defense attorneys for the people we represent.
Go ahead.
Go ahead, sir.
Okay, thank you. My style, I don't know exactly how you describe it, but I've been doing it for 20 years in this office in leadership roles. And I consider myself like a union rep when I was chief assistant. And I talked to many a lawyer and I talked to them about many cases. I would brainstorm with them. I would sit down with them and talk to them about the specifics of their case, how to conceptualize their case. And if they had problems with the administration, we would try and navigate those issues through discussion, negotiation, and compromise and understanding. That is my leadership style, is conciliatory, is to try to do the best for all concerned. But the one thing that is very clear about me that probably is different is the clients are primary. The clients are primary. And that has to be the number one concern. And so I will not make a lawyer-centric, elitist office at the expense of other staff or the expense of our clients. And that just will not happen. If I'm reelected, we will have a meeting where I will say, look, this is the way I've wanted to do things by the team concept, using social service, mental health services, teams, not some type of elitist, like we're a silk stocking law firm. We are a public defense firm. We are a battalion. If you can get with the agenda, if that's what you want to do, nobody's going to get fired. Nobody's going to be dismissed. I will allow everyone to remain and give them an opportunity to see if they want to stay and work with that type of leadership. And if they don't, they're welcome to go.
Mr. Thomas, thank you very much. The question asking now turns to me, and the question will first go to Mr. Thomas, followed by Ms. Yeary. The question is, you've both talked about crippling caseloads in the office. Give us one out-of-the-box idea that you could put into effect on day one of your first term or your second term, as the case may be, to improve the caseload problem. And again, Mr. Thomas, you'll go first.
I can't think of a thing that we can do to decrease our own caseload because we don't control it. The one thing, again, that we can do is we can try and stop the over-policing, the overcharging, and that would slow the pipeline. We could also propose a domestic battery diversion court, a DUI diversion court. There are a number of jurisdictions that do divert cases away into diversions. That reduces caseloads. We could ask Mr. Campbell to use civil citation more often. But as far as manipulating caseloads, they are more dictated to us than us controlling them. What we've been trying to do is get funding, get more positions so that we have more bodies and more boots on the ground to actually cover the cases. We got 2 positions funded for mental health positions because that's an exploding area, and we probably will not be able to fill them because of COVID-19 budget cuts. probably until a year or two from now. But what it really takes is more personnel and more reasonable prosecution practices.
Mr. Thomas, let me stay with you and let me ask a quick follow-up based on your answer. Increased personnel, extra specialty courts, don't they all cost money? And where does that come from, if so?
It has to be appropriated by the legislature, but they have been doing that. They've been expanding drug court, expanding veterans court, and they seem to be receptive to the therapeutic courts because in the long run, they promote public safety and they save taxpayers dollars, is the bottom line. So it's a good investment overall. But again, even in the environment before COVID in the last session, we got $150,000+ for 2 positions because of the mental health crushing caseloads. And again, if in a regular world without this pandemic, that would help us very much in alleviating caseloads in that arena.
All right, Mr. Thomas, thank you very much. Ms. Yeary, go ahead and answer the same question. And if you need extra time, I gave it to Mr. Thomas to expand on his answer. You'll have it, but go ahead and answer the same question about what you can do as the public defender about caseloads, if anything.
The fact that there's no plan or there's no attempt to change caseloads is troubling to hear. Right now in the Leon County Public Defender's Office, the misdemeanor lawyers are carrying 200, 250 clients, 254 clients. So the first thing I would do is get in there and take a caseload. I would get down in the courtroom and help my assistants to tackle this amount of caseloads and make sure that I was there helping them alongside of them instead of dumping a 250 client plus caseload and said that I might be able to help after the election. The first thing I will do is be getting in there and doing that work with the lawyers that I'm side by side with. We have to set that example. The elected public defender, the chief assistant, they should be handling cases. That is the norm in other public defenders' offices. And to just say that there's really nothing we can do because the state attorneys keep overcharging, well, that's not going to change unless we get in there and push back on that. Creative ways would be the first thing to handle second-degree misdemeanors. In Florida, second-degree misdemeanors are the lowest possible crime that there is. In those cases, let's approach the prosecutors and say, hey, during COVID, let's do a deferred prosecution agreement where if these clients don't get into any more trouble for the next 6 months, their case gets dismissed. It's a second-degree misdemeanor. Let's let that go. Then let's start setting up court dockets. One of the biggest issues we had is that the state stopped accepting pleas in absentia or cases, plea forms for people that were out of custody. We need to get those back into place. And I worked on doing that as president of FACDL. So first and foremost, to attack these crippling caseloads, you have to get in there and do the work with them. I was a county court division chief. I handled a county court docket for 2 years. So I can sit down with those lawyers and teach them and handle these cases by defending clients.
And Ms. Yeary, thank you very much. And again, I'll have to ask you a question, a direct follow-up question based on your answer. You've said now several times about getting into the courtroom, taking your own caseload, having a chief assistant take their own caseload. Doesn't that create a problem of, if you're in the courtroom a lot, who's kind of driving the train, as it were? And how do you deal with that?
So we have administrative positions within the office, but also when you give the lawyers and the leaders in your office the tools to succeed, they'll continue to do the work too. So of course, a component is being in the courtroom, but that is our work. We can continue to be administrators and to be managers. And that's what I did as a division chief. I would hire, I would be on hiring committees. I would put on certified legal trainings where I would try and teach other lawyers and also handle my own caseload. It's a multifaceted role, but that's what you do as a leader. So I absolutely can continue to handle clients and defend cases while also managing the office. And if you invest and give your lawyers the other tools that they need to be successful, then they'll keep doing the work within their own divisions also.
Oh, and thank you for that. Mr. Thomas, let me give you an opportunity to respond to that extra question that I asked to her answer.
Well, I think I know there is a huge difference between being a county court division chief and supervising 3 or 4 people or being a felony division chief and supervising 2 people and running an office with 65 attorneys, 130 employees, appeals from 32 counties, trials in 6 counties. It's a huge difference between being a division chief and having to work with the legislature and go to board meetings and go to forums all the time discussing community issues. There is a lot of work that happens in this particular job that is outside of this office. And I can assure you, if you try to manage a caseload full-time and also do this job, the clients are probably going to be the ones that suffer.
Maybe I should give 30 seconds to Ms. Yeary for a rebuttal.
Clients are not going to suffer when we have lawyers that are trained and committed and in the courtroom fighting for them. And that's what I did as a division chief. That's what I'll continue to do as the public defender. We have administrative and manager roles and other employees through our support staff in the office. So we will continue to be all hands on deck. It is a lot of work, but it is meaningful, important work. And our clients will not suffer by the leader of the office and the chief assistant and the other division chiefs getting in there and representing clients zealously.
Thank you very much. Moving on to our next question, we will be turning it over again to Christine Coble of the League, and Ms. Yeary, you will answer first. Christine Coble, go ahead.
Thank you. What other advocacy roles should the public defender be playing in the community and why?
We have to be an advocate for justice. The public defender's office represents the majority of people that are accused and arrested in our circuit. It's about 80 to 85%. So we have to be present in the community championing these issues that we see. When we see issues of police misconduct, we have to ethically and effectively be out there challenging those issues and having those critical conversations with law enforcement, with the state attorney's office. We also have to be educating the public. We are criminal defense lawyers. Let's put on the Know Your Rights seminars. Let's be present in the community, teaching our children how to have police interaction or what their rights are if they have involvement with the police. Some of the incredible work that other offices have started is a first offender response program. Let's be lawyers that are out there that are available for interrogation if a client's arrested over the weekend. Let's start thinking of other innovative ways that we can support our clients through the criminal justice process other than just the courtroom. Because we know when clients come to us, they've already been arrested, they've already made a statement, they may have had other evidentiary issues there. And so we need to be there challenging that. But in the community as a whole, it is time for action on the part of the public defender, being present for these critical conversations and standing up for our clients. There's an important conversation happening at the courthouse, and that conversation is being driven by the state attorneys and law enforcement, and the critical piece missing is the public defender's office.
Thank you. Mr. Thomas, your response.
That's inaccurate. The conversation that's going on in the courthouse is between the public defender, the state attorney, the sheriff, the chief judge, and the chief administrative judge of the criminal division. And that conversation went on daily for weeks and weeks after COVID first hit. And it's not just COVID. This happens on a regular basis. I talk to the stakeholders in this building probably once a week about various subjects. And I have told Chief Revel, I have told Sheriff McNeil that the cop squads and the spider squads and the stopping people for a cracked taillight and bringing out German Shepherds to rifle through the cars must stop. And even if the law allows them to do that, which it currently does, we should be stopping it in this community. And we cannot do that by filing motions all the time. We have to do that by being engaged with the stakeholders. I have been at forums at Reverend Holmes Church about policing and about racism and about trying to get reconciliation going. I have been to speaking engagements all over this county and all over the circuit. So community engagement is there. It's just a matter of you can't go to everything all the time and run this office. Running this office is your number one obligation. Under Chapter 27, we represent all people who are jailed or are threatened with a loss of liberty, and that is our job. Our job is not to go out there and be a community activist.
Mr. Thomas, thank you. Ms. Yeary, I'll give you 30 seconds for rebuttal.
Our work in having conversations with law enforcement, when of course we need to be professional and ethical and on issues that we can work together on, we absolutely should be. But that is where the accountability comes into place. We are the lawyers that are defending our clients. So if they're not going to stop with Cop Squad and they're not going to stop with bringing dogs out for every pretextual stop that happens, we file the motions. We do the work through our legal means. When we look back at the civil rights movement and the changes in the law that occurred there, that came from lawyers fighting. And yes, maybe we will lose some of the time, but for the cases we don't lose, we make meaningful impact for the people we represent, and we work hard to change the law to their benefit.
Thank you very much. At this point, what we're going to do is ask each of you to ask the other a question and allow for a response, should you so choose. Ms. Yeary, you went first last time, so we'll do it this way. Mr. Thomas, you can ask a question to Ms. Yeary and get a response, and then Ms. Yeary, you can ask Mr. Thomas a question and get a response. Mr. Thomas, do you have a question for Ms. Yeary?
Yes. How many lawyers in the office currently will you fire if you're elected?
Ms. Yeary, go ahead.
Sure. When I'm elected, I will be back in the office and we will work together to make the critical change that we need to defend our clients. I am not going to sit here and say that I will fire lawyers or I will fire people that, contributed or did whatever. The issue is in the office, and you can see this through the mass turnover that we have had in the public defender's office under this administration, that there is a critical need for change in leadership. And so we will have to get back in there and work together, but we are going to refocus our mission and change the environment of our office. Our office has to be one that supports the lawyers, that invests in them, that treats them with respect and dignity, as well as our legal staff, our support staff, and our investigators, and that we come together with a unified mission, which is defending our clients and making a difference for them in their lives and in their community.
Thank you very much. Now, Ms. Yeary, you also now have the opportunity to ask a question of Mr. Thomas.
Is your role as the public defender to manage an office or to defend clients?
Mr. Thomas, go ahead.
I'll answer your question. You didn't answer mine, but I'll answer yours. My job is to do both. My job is every pleading that goes out of this office, every discovery, every motion, every brief done by appeals says Andy Thomas. I represent roughly 16 to 20,000 clients a year because my name's at the top. So yes, I represent clients, but my job is also to manage this office and empower these employees with the resources and the tools that they need to succeed. They need to know that they're going to be able to make enough money to pay their bills. We have people here that are working 2 jobs in support staff roles. We've been fighting very, very hard to get 3% across the board, if not higher raises, and we finally just got it. Now it's going to be taken away by budget cuts. So yes, representing clients is primary. That's what Chapter 27 says. That's our mission. But managing the office is vitally important as well.
And Mr. Thomas, thank you very much. Before we move on to our closing arguments, we're going to squeeze in one more audience question, and that is this. We have an audience member who says she's a regular volunteer at the jail and says she sees many cases where defendants don't get to meet with their PD even once before court. The question is to both of you is, as far as you know, is this true, and what needs to be done to change that? Ms. Yeary, you will answer first. Go ahead.
It's true in some cases. It's not true in all cases. There are committed, incredible lawyers in that office, and there are lawyers that don't take their job as seriously. So that is absolutely the case in some cases. Many other public defender's office and how I practice in the office is to require client contact. If your brother or your sister or your family member was in jail, you would absolutely expect that their lawyer spoke to them. The Orlando Public Defender's Office requires that the first contact with a client in custody be face-to-face. The West Palm Beach Public Defender's Office not only makes you go through an entire formalized training program before you even have contact with the client, but they routinely check into how many contacts you're having with that client at the jail. I tell my clients now in private practice, I try at least once a week to touch base with them in custody, because people are making life-changing decisions by taking a plea, by not taking a plea, by setting their case for trial. And they cannot do that if they do not have lawyers that are communicating with them, and lawyers that are keeping them updated on their discovery, on the legal options that they have, what their rights are, or what the consequences would be if they took a plea. So it is going to take a requirement and a change again in the environment of the office that says we will absolutely remain in contact with our clients, and they are our first priority, being lawyers for them.
Thank you very much. Mr. Thomas, go ahead and take that same question.
We have the greatest capability of being able to video our clients, probably of any law firm in the state. We can sit at home with a laptop. We can sit in our offices. We can dial up the jail, and we can bring up our client at any time. We have a lot of contact with our clients. I do not doubt that there are lapses. We do monitor it. We have the ability through our case management system to know who is accessing their files, who is checking on their clients, the notes that they make on the cases. But I will tell you this, I take complaint calls probably as much or more than anybody in this office. And most of the time when I get a call and it's somebody saying, oh, Mr. Jones has been in jail for 3 months and has not talked to his lawyer, it is not our client. It belongs to someone else. It's not a public defender client. And in the rare case it is, remedial action is taken immediately, and there is sometimes some type of reprimand or punishment if it is a gross abuse of your duties. That has been exceptionally rare. I believe that we probably have more contact with our clients than anybody out there.
Mr. Thomas, thank you very much. We're closing in on the 2 o'clock hour, so at this point, I'm going to go to closing arguments. You will each get 2 minutes to explain why voters should vote for you rather than your opponent. And Ms. Yeary, you have the first opportunity to make a closing argument should you choose. Go ahead.
Thank you, and thank you for this opportunity. I have dedicated my career to being a public defender, and so many of my colleagues and supporters of our work in this campaign have done the same. You can see the lawyers that spent their lives in this office that are supporting my leadership style and my plan to make meaningful change in the criminal justice system by defending the clients that we are here to protect. This 2020 has shown us that the status quo and doing things the same, the way we've always done them, is simply not working. Now is the time for action and not absence. And we need committed leaders that are not afraid to say, well, there's nothing we can do, or this is the way it's always been. We have to get in there and do the work. I am board certified in criminal trial law, which means that my level of skill, knowledge, and expertise in criminal defense has been rigorously evaluated by the Florida Bar. I am going to implement a training program that gives our lawyers those tools and that same level of knowledge so that they're in a courtroom fighting for our clients with the skill that they need to make a difference. As caseloads continue to climb, I'm not going to say there's nothing we can do. I will continue to make creative new ideas that will help our clients get out of this system. But what I will tell you that I'm most proud of and why I deserve your vote is because this is the work that I have done my entire career. I was never a prosecutor. I have never done anything else. I left the public defender's office under this current administration, like so many others did, to come back and make it better. We need lawyers in the public defender's office who will defend their clients, because we know that your level of economic security, that the color of your skin should not be a determining factor in how your case is resolved. And we have to be lawyers who are not afraid to not file a motion because we might lose, and are going to get in there and be compassionate and persuasive lawyers to juries and to judges in our circuit. I will be your attorney. Thank you.
Thank you very much. And Mr. Thomas, go ahead. The floor is yours.
Thank you. I appreciate the opportunity. I was honored in 2016 to be asked to run for public defender by Nancy Daniels, who was here for 26 years, is a mentor, friend, and boss of mine. It should be obvious at this point that this is not just an attack on me by my challenger, it's an attack on my predecessor. And she endorses me again this time. I'm proud of that endorsement. I'm proud of the fact that not only does Nancy still endorse me, despite certain allegations against me, but that I have the support of retired judges who know the criminal justice system. I have the support of experts in the fields, psychologists, neuropsychologists, and people who actually know what we do. That's the reason for that is because I've been doing this for 39 years and I've been doing public defense for 35 years. And so, yeah, I prosecuted a couple of years. That was a long time ago. I learned a lot and I use it against them almost every day. So that's not a detriment. I have 4 times the experience of my opponent. I have been in supervision all of these years. I know how to do this job, and I want the opportunity to continue to do it because I do think we can improve on the model, and we'll keep on going forward with a holistic approach to public defense, with social services, with mental health services, and great advocacy. Appreciate your vote on August 18th.
Mr. Thomas, thank you very much. And that's all the time we have. I want to thank the League of Women Voters of Tallahassee, Christine Coble specifically, for being here. Thank you very much.
Christine.
Thank you.
I also want to thank both candidates. Again, Jessica Yeary, who's running for public defender, 2nd Judicial Circuit. Thank you.
Thank you. Thank you for this opportunity.
Most welcome. And Andy Thomas, the incumbent public defender for the 2nd Judicial Circuit. Thank you for spending some time here with us today.
Thank you for the invite.
Our next forum will be 1 p.m. Tuesday, and it will be with the candidates for Leon County Sheriff. You can find a replay of this forum and all of our interviews at tallahassee.com/elections. And I would ask you to look for our special election section, printed section, which will be out Sunday, August the 2nd. Once again, I'm Jim Rossica, the news director here at the Tallahassee Democrat and Tallahassee.com. Thank you for spending the time with us this afternoon, and we hope to see you at another forum in the very near future. Thank you very much. Good afternoon.